Hey guys, welcome to this video. We'll go through this case decision out of the Southern District of Florida. And this is a lawsuit brought by somebody who's pro se. They didn't have a lawyer. And we're not so much interested in the kind of the details of it, but I really want you to see this case because the judge has a good discussion of what's called a motion to reconsider. In other words, a judge rules against us. Can we just say, hey judge, you should reconsider this, you should change your mind? Or is there more to it than that? So basically, this is a foreclosure proceeding in state court that started all this. And in Florida, foreclosures are done in a judicial manner. So the comparison is with Alabama's non-judicial. So in Alabama, there's no court involvement. The mortgage company sends you a couple of letters, they advertise in the paper, and they stand outside the front door of the courthouse, and your house is sold. No judge is ever involved. Totally opposite in Florida. Florida, there has to be a lawsuit brought, and that lawsuit, it's just like a normal lawsuit. You have to be served with it, and then the mortgage company has to win that lawsuit to be able to foreclose on your house. So the plaintiff says, hey, they lied to me and tricked me into signing a settlement and a consent final judgment of foreclosure. In other words, the plaintiff agreed that you can foreclose on my house. And now he says I was tricked with that. And so he says the defendant didn't have the right to seek for foreclosure. And so he sued under the FDCPA, Fair Debt Collection Practices Act. And the judge tells us that previously he sought a temporary restraining order. So it's often called a TRO. And the idea there is you file a lawsuit, you find a judge, and you say, look, this is really serious. I need you to temporarily order the other side not to do something. And it's typically good for 10 days. And so he sought a temporary restraining order. Then a preliminary injunction is good after that up until the final trial. And then a permanent injunction would be you win at trial and the other side is ordered to do something or not do something. So basically what he was saying is tell the other side, the mortgage company, they cannot evict the family living there. And I don't know if the plaintiff lived there or just his family or what. But anyway, the court denied that. And so the plaintiff now seeks a reconsideration of that order and says this is an emergency. And so again, asking for a temporary restraining order, preliminary injunction so that they won't be evicted. And now the court tells us the law. It says a motion for reconsideration. And I'll say this, in state court, depending on what state you're in, some judges in some state rules are much more liberal on this. But in federal court, in the 11th Circuit, this is what you find. It's an extraordinary remedy. It be employed sparingly. And so you can't just use it to re-argue what you did before. So sometimes we sue a defendant and they file a motion, they lose, and then they just refile the same thing. Like, hey, judge, maybe this time you'll get it right. The judges just have no interest in that. So when can you grant reconsideration? So the judge outlines three possibilities here. The law changes. So judge issues a ruling, and then maybe the next week, the next month, the appellate court or the U.S. Supreme Court changes the law. So the basis of that judge's opinion is gone. That would be number one. Number two, the availability of new evidence. And typically it has to be evidence that you did not know about and could not have known about. Or number three, there's just a glaring error in the judge's order that needs to be corrected. So here's another way of describing it. Patently misunderstood a party, made a decision outside the adversarial issues presented to the court by the parties, or made an error not of reasoning but of apprehension. Again, we're talking about just, it's not that you got the wrong decision, but that it's just completely wrong. And a motion for reconsideration is not an opportunity for the moving party to instruct the court on how the court could have done it better the first time. And so here the plaintiff says, the basis I'm going under is a clear error. So remember up here, we've got these kind of three possibilities. Well, the plaintiff here says it's this clear error. And so, well, what is that? It says, it's a fundamental error in concluding he failed to show irreparable harm. So that's a requirement to get an injunction. In other words, Judge, you must stop the other side, because if you don't, there's no way to fix this. And he says because there's no allegation defendants had taken any action to evict plaintiff. So he's saying, look, Judge, you messed up because you based your ruling on the fact that the defendants weren't trying to evict. The court says, I disagree, and it's not well taken. And while we don't get a whole lot of detail here, it just says it's no more than disagreement and re-argues points already considered. It's improper to use motion to reconsider, ask court to rethink what the court already thought through, rightly or wrongly. And when there's mere disagreement with the prior order, reconsideration is wasted judicial time and resources, should not be granted. So therefore, it's denied. So again, I want you to see this just because sometimes when a court rules against you, there's the immediate reaction of, well, can I appeal it? Well, normally you cannot appeal unless it completely resolves the whole case. There are exceptions, but that's the general rule. So a lot of times the orders are not such that we can appeal them. And we say, well, the judge just missed that. I want the judge to reconsider. She just made a mistake there. Well, it's got to be more than that. Again, we come up to these three ideas up here. Is there a change in the law? We can say, Judge, you made a decision based on the way the law was. Well, now it's changed, so we want you to reconsider. That's fair. Or, hey, Judge, here's some new evidence that we didn't have before, particularly if that comes from the other side. So we sue a defendant hides evidence, we lose a motion, then we discover that evidence, and we're like, hey, Judge, they hid this evidence from us, and that would have made a difference, and judges are receptive to that. Or where it's just this horrendous error, clear error. But the point is, very rare that this happens. That's why you need to win during the first go-around, because judges look very skeptically, at least in federal court, where you just ask them, please reconsider this. So thanks for watching this video, and if you have any questions or comments, put those below. And if you want to get in touch with me, it's 205-879-2447. My name is John Watts. So 205-879-2447 or alabamaconsumer.com, and I'll catch you guys in the next video. Thanks a lot. Bye-bye.